Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
This season, Instacart has your back to school. As in, they've got your back to school lunch favorites, like snack packs and fresh fruit. And they've got your back to school supplies, like backpacks, binders, and pencils. And they've got your back when your kid casually tells you they have a huge school project due tomorrow. Let's face it, we were all that kid. So first call your parents to say I'm sorry, and then download the Instacart app to get delivery in as fast as 30 minutes all school year long. Get a $0 delivery fee for your first 3 orders while supplies last. Minimum $10 per order. Additional terms apply.
Achieving a gorgeous grin from home isn't a total mystery with Bite Clear aligners. Just don't be surprised if all of your sleuthing friends start asking, "What's your secret?" Begin by ordering your at-home impression kit today for only $14.95. Bite Clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces. Plus, they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning. This episode contains discussion of the murder of 2 girls.
The other day, there was a major filing in the Delphi case. It was only 1 sentence long.
Motion for early trial. The defendant, Richard M. Allen, by counsel, moves the court for an early trial within 70 days, pursuant to Criminal Rule 4B1 of the Indiana Rules of Procedure.
We'll talk about this filing and what it means in today's episode. We're fortunate enough to talk to a lot of wonderful lawyers about legal issues in this case. Today, we'll be hearing from 2 Indiana lawyers that we've had on the show before, Public Defender Timothy Sled and Defense Attorney Mark Inman. They'll weigh in on the concept of early or speedy trials and give us some insights on what we might expect to happen next. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is The Delphi Murders, a conversation with 2 attorneys about the motion for early trial.
So, under Indiana and federal law, citizens have the right to a public and speedy trial, Let's read the section of the Indiana Rules of Criminal Procedure that deals with this.
Speedy trial requirements and remedies. Rule 4. Impact of delay in criminal trials. A. Defendant in jail. If a defendant is detained in jail on a pending charge, a trial must be commenced no later than 180 days from the date the criminal charge against the defendant is filed, or from the date of arrest on such charge, whichever is later. Delays caused by a defendant, congestion of the court calendar, or an emergency are excluded from the time period. Any defendant detained beyond the time period of this section must be released on recognizance, but continues to be subject to the criminal charge within the limitations provided for in Section C. B. Defendant in jail. Motion for early trial. A defendant held in jail on a pending charge may move for an early trial. If such motion is filed, a trial must be commenced no later than 70 calendar days from the date of such motion, except as follows. 1. Delays due to congestion of the court calendar or emergency are excluded from the 70-day calculation. 2. The defendant who moved for early trial is released from jail before the expiration of the 70-day period. Or 3. An act of the defendant delays the trial. If a defendant is held beyond the time limit of this section and moves for dismissal, the criminal charge against the defendant must be dismissed.
Section C deals with situations where the defendant is not incarcerated. That obviously is not the situation here with Richard Allen, so we're going to skip ahead to the next section.
D. Dismissal for delay in trial. When may be refused. Extensions of time. If a defendant moves for dismissal under this rule, the trial may be continued for 90 days and the defendant released without money bail or surety, subject to such restrictions and conditions as determined by the court. If the state shows the following: 1. There is evidence the state would be entitled to present at trial. 2. The evidence is presently unavailable. 3. A reasonable and diligent effort was made to procure the evidence in a timely manner prior to moving for an extension of time. And 4. The evidence can be obtained within 90 days. If the defendant is not brought to trial within the 90-day period, the criminal charges against the defendant must be dismissed with prejudice. For purposes of this section, the evidence sought need not be essential or unique, nor is the state required to actually present such evidence at trial. However, if the state fails to make reasonable and diligent efforts to procure the evidence after the court grants the extension, the court may dismiss the criminal charges against the defendant with prejudice.
With all of that in mind, let's hear from Tim Sled, who is a public defender in Lawrence County, Indiana. We've had him on the show before. He was kind enough to talk us through some of the points around this concept, despite the fact that he's preparing for a speedy trial of his own. So, what is a speedy trial request?
A speedy trial or an early trial is a specific request by a defendant to be brought to court within 70 days of the request being made. This is something that fast-tracks cases and gets them to be brought to trial within 70 days of the request.
Is this something that's an automatic thing? If a request is made, must the judge grant it?
I don't know the answer to that, but I presume yes. I've never known a judge to deny a speedy trial request that was made appropriately. Now, there are inappropriate ways for somebody to make a speedy trial request, such as they have an attorney of record and they write a letter pro se to the court requesting a speedy trial. I've seen judges deny those as not being appropriately filed. But I've never seen a judge deny a speedy trial request that's been made, probably because it's a constitutional right. I wasn't expecting that question, and I've never experienced it. I think because it's a constitutional right, judges take it pretty seriously and get it set.
No, that makes sense. Like that's typically the way things go. I'm curious, is there any strategic benefit for doing a speedy trial request as far as the defense is considered, just in cases in general, not speaking specifically on Delphi?
So to answer your question directly, yes, there can be strategic reasons why you would file for a fast and speedy. And most of the time, it's when you believe that there is material evidence that's necessary for the state's case that they can't acquire, obtain, find, or present to a jury within that 70-day window. I have successfully had cases get dismissed after filing fast and speedy trials where I knew that the state was not going to be able to get the complaining witness in to testify at a deposition or come to trial because the complaining witness is gone, incarcerated someplace else, or not cooperating with the state. Another reason fast and speedy trials are filed frequently is because the state toxicology lab or the state lab and the State Department of Toxicology is the two different things, but they process the evidence at a snail's pace, and if they have a quantity of a substance that's necessary to be proven in order to reach a level of an offense, they may not measure that substance, for months and months and months. But if you get a trial date set, it expedites the measurement. So, there have been times when my client says, I know exactly how much there was, and there wasn't that much. They must be weighing the bags or weighing other stuff with it, and it gets you under a threshold weight for a charge. Then, filing the fast and speedy gets the case put on the docket, gets the state lab moving toward the results. And then when the prosecutor gets the results that show it wasn't the amount that they thought it was, they have to amend their charge or dismiss their counts, or go to trial and lose on those counts. So there can be strategies, but typically the strategy is you believe that you know material evidence that the state will not be able to produce that's necessary to their case, and putting them under the time crunch either will expose that or facilitate that.
So it's kind of like telling the prosecutor, put up or shut up?
Yeah, I think that's exactly right. You can be doing it saying, well, we're all in. I mean, it is in using poker parlance, it's pushing all of your chips to the middle of the table. You're all in if you go fast and speedy.
Can it backfire?
Absolutely. I was taught in my early years of defending that the state's case never gets better with time. So catching a case and processing a case while it's fresh in the investigator's mind, while it's fresh in the prosecutor's mind, you're going to be facing a case that the ink on the paper is very clean and easy to read. But if you let a case age, people's memories fade, people's organization causes them to lose things that they might need. And so there is a possibility that, with delay of a case, you ultimately will get better. I often tell my clients, right now, you are the hottest burner on the stove. We don't want to go and try to strike a deal or do anything right now because the prosecutor is dealing with you as the hottest burner on the stove. Let's let you cool down and let somebody else who's hotter pop up and take their attention, and then we can strategically move to negotiate or try the case. So the backfire that can happen here is you've now given, by asking for a speedy trial, you've now given your counsel 70 days to polish everything up to be ready to get in front of the jury, to organize all of the material so that and master all of the material. You've put the time clock of 70 days on it or less, and you got to be ready. You got to go. If there's, for example, in a case that I have that's set for a fast and speedy, pretty much everything else has been pushed to the side so that we can get all the depositions done, get all the docs reviewed, get all the witnesses subpoenaed, communicate with all of the witnesses to make sure they're going to be able to be there on the days that they're being subpoenaed to be there. So it's an immense amount of pressure you put on defense counsel, and typically the state, either by way of its investigators or its prosecutors, they know their cases really well, and they probably have at least two people, the investigator and the prosecutor, that are going to be somewhat able to organize the case. So they shouldn't be on their back foot. But if they're on their back foot, then a fast and speedy might be a good strategy to shake them and to try the case if they can't meet a material element. If they're not on their back foot, if they're prepared, if they're ready to go, it's going to be a harder row to hoe for the defense lawyer than for the prosecutor, but that doesn't mean the outcome will necessarily be negative.
Can you essentially undo or take back a request for a fast and speedy trial? Is there a way to, if you change your mind as a defense attorney, can you revoke it?
Yeah. The client has to revoke it. It's the client's right. So once the speedy trial has been requested and granted, in my experience, if the defendant, the client, wants to withdraw the speedy trial right, there's usually a hearing with an advisement of rights. And this is an extreme disruption of the court's docket and calendar. So courts don't clear their calendar, get a fast and speedy set, and then just willy-nilly, pull upon a request, pull the fast and speedy because they've got to use their docket space very, very carefully. So you can pull. I mean, I've had cases plea out after fast and speedy has been filed. I have had clients say, well, we really now know that our lawyer needs more time because things have come to light through the expedited discovery process that happens during trial preparation, that we need more time. And so we're going to lay off the gas of this fast and speedy and go back to the normal trial docket. And when Kevin asked me the question, can a judge deny it? One of the things that went through my head was, I'm wondering if a judge can deny a second or third motion for speedy trial when a defendant has already asked for one, been granted one, and withdrawn one. That was a question that went through my head, but I don't know the answer to that. Off the top of my head, I've never been in that situation, but I could understand how a judge could get very frustrated with a defendant who filed for a speedy trial. It's the trial set, clears the docket, and then withdraws the fast and speedy, and then does it again because it is extremely disruptive to the court calendar. There are usually folks in the wings waiting to have their cases tried, that when you file for a fast and speedy, you now raise yourself to the top of the trial list, and those people get subverted and their cases get what's called congested off under CR4. If they have a trial date that's set and a speedy comes in front of them, their case gets congested off and the court has to find another date for those trials. So if you then pull your fast and speedy, those folks don't get their counsel won't be ready. They don't get a trial. And so they're left in the lurches. So it can be very disruptive. I know that in the fall and winter of 2023, I filed a fast and speedy for one of my clients, and it raised him from being like a 9 or 10th setting to the number 1 setting for incarcerated folks for trial. And, there were people that had been in jail, much longer that had normal trials set that got subverted to his fast and speedy.
Absolutely. At that point, it just sounds like it might become the legal equivalent of Lucy pulling the football away from Charlie Brown.
Yeah, that's a
to
great.
To put it in very
analogy.
stupid terms.
That makes sense. Yeah.
I'm curious, how common is this? Is this something that gets filed for often in the state of Indiana?
I think it is pretty often. I would say I don't file them often. My office doesn't file them often, but they're filed enough around the state and within my office that I can say that they're not abnormal. It's a calculated measurement with the client's desire and the readiness of the case to be tried, along with perceived weaknesses in the state's case. When all of those things come together in sort of a perfect match, then it can be strategically the right move to make. It can also be, as Kevin said, a put up or shut up. If you got a prosecutor that's not seeing a weakness in the case or not thinking there's a weakness in the case, and you're serious about resolving the case and they haven't given you anything to lose, it can be something that says, well, now we've got you in a position where, it's a binary equation. You're either going to win or you're going to lose. And, often negotiations speed up because of the filing of a fast and speedy. I do think it's fairly common, though. We read enough cases where we see that the case was brought with a fast and speedy. The percentages, I don't know. I don't have that data. I think the average is around 8% of cases that are filed get tried, and so probably only a quarter of those, if that, are fast and speedies would be my guess. It's rare in the terms of if you have a criminal case, is it going to go to a fast and speedy trial? No, that would be very rare, but it's very rare that a case even goes to trial. I think the stats are 92% are pled out. If they're pled out or dismissed, and then 8% get tried, and the defense mantra is the state's case doesn't get better with age, you're probably not going to rush too many of them through to trial. But again, sometimes it's the way to go.
That makes a lot of sense. Just from your own personal experience with these sort of things, how stressful is it for the attorneys to do this? It sounds like it can be a great strategy, but also sounds like be a lot of work. So what's that experience like preparing for a trial that you've requested be speedy?
Yeah, so it's case by case, and because cases vary in complexity, but the more complex the case and the tighter the time frame you have to really get down to the brass tacks and get ready for trial, it would be very stressful, very time consuming. The more complex the case, the more you're going to be in it, whether it's a fast and speedy or a regular jury trial, you're going to be spending a lot of time getting ready. If you have a 3-witness case, let's say you've got an OWI case, an operating while intoxicated case, where you have the pullover officer, you have the drug recognition expert policeman who does the SFSTs, and then you've got the blood draw technician. That's 3 witnesses. If you're going to do a fast and speedy on that, and you've got 70 days to prepare, you're probably going to put in about the same amount of work you would if it was like the CR4 180 trial. I mean, it's not going to take you that much extra work, because you're going to have body cameras to watch. You may do a deposition here or a deposition there, but you can get that done in 70 days. But if you have 50, 60 witnesses and you're starting from fresh, that's a lot to get through in 70 days and to get prepared for. If you've had a case for a very long time and you've prepped the case and you're ready for trial, as I was in the fall, I was ready for trial when I filed for my fast and speedy. We already knew what the evidence was. We already knew what our case was going to be. We were waiting on one particular witness to resolve a case so that then they wouldn't have a Fifth Amendment right, and I could depose them without them asserting the Fifth Amendment right. That person pled out. We deposed them, and then the day after that deposition, we filed for a fast and speedy because my guy was in jail and wanted to get the process moving forward. So that case, there was very little stress, or very little additional stress, because it's fast and speedy. We were already ready. But in other cases where you come to learn that there's even more and more evidence that wasn't obtained by the state before you file your fast and speedy. Now you've got to catch up. You've got to learn it. You got to prepare for it. You got to figure out where the puzzle piece fits in. It can be very stressful. Imagine, I know you like to use analogies, but imagine that you are going to play a game of chess. Okay, playing a game of chess is one thing. It can be very difficult. You need to be looking ahead many moves, all the strategy. You got to be thinking about the movements each piece makes. Now, play timed chess, where there's a clock ticking, and if you run out of time, you lose. And let's say that time is half the length of time that you would normally have to play. It's automatically you are more inclined to make mistakes. You're more inclined to move quickly. You're more inclined to be a little looser in your gameplay or your strategies, because you got to get moving. So there are some additional stressors that can come with trying a case within 70 days.
Absolutely. Well, this has been great, Tim. Thank you so much. Is there anything we didn't ask you about that you think is important for people in regards to understanding this topic?
The risk and the reward will often come down to the relationship between the client and the attorney, the defense lawyer. If they are communicating well, if they are on the same page, if the lawyer is being heard and the client is being heard to limit sort of surprises, then it's a heavy decision to make, but it can be the right decision given the right circumstances. The concern I would have as a supervisor of lawyers is if I had a lawyer that was saying, hey, I think I want to do a fast and speedy trial on this case, it would be, well, let's make sure the client understands the risks and the rewards. Let's make sure that you can see not only a tree, but you can see the forest, because it's going to come rushing at you very quickly. And you're going to want to be able to, to bob and weave and duck and move and spar where necessary, but also avoid spinning your wheels in mire that can be a time suck when you don't have any time to lose. It's I have had clients, the first time I meet them, say, file a fast and speedy for me. And I say, okay, you're going to hamstring, because I need to be able to analyze your evidence. I need to be able to test the state's case. And if you want this fast and speedy, I understand that's your right. I will file that for you, but I'm going to be limited in the amount of time I have to prepare. Why don't we get the evidence first? Why don't we analyze the evidence? Why don't we see what they do and they don't have, so that we're not surprised? We can always make the decision to file later. But sometimes that's not the right choice for the client. And in my practice, under the commission that we're with, it's client-centered practice. If the client is informed, understands, knows what's out there, has been advised, and is wanting to exercise that, then we will file and exercise that for them. It is a grave decision, a heavy decision, because when you put the case in front of the jury, it's then in front of the jury. They get to decide, they get to analyze, they get to weigh credibility, they get to determine the facts, and they get to determine the law to a certain extent. And it's no longer in your attorney's hands. And so to make the decision to go to trial or to go to a fast and speedy trial, the client really needs to understand the gravity of that. Depending upon the complexity of the case, it can really be handicapping, sort of in a golf sense, handicapping to an attorney to have to prepare the trial within 70 days of the motion. Now, that's presuming that the case is relatively new to the attorney. But if the attorney has a case for a very long time, they could have been strategizing this all along, that they might be laying in the weeds, preparing their case, ready to go, file a fast and speedy, and hamstring the state. But typically, from my experiences, the prosecutors aren't too hamstrung by that, because they've got teams of investigators, or even if it's just one investigator that is going to have lived their case well enough to put it together within 70 days.
Absolutely. Well, Tim, thank you so much. We really appreciate you taking the time to do this.
No problem.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
What makes a life a good one? Is it the adventure you have? Or the friends you find along the way? Maybe it's pursuing your passion while striving to protect, defend, and save what you believe in every single day. So, what makes a life a good one? In the Coast Guard, we think it's all of the above and more, but you'll have to find out for yourself. Visit gocoastguard.com to learn more.
Welcome to another round of Boardroom or Miro Board. Today we talk retrospectives with Agile coach Maria. Let's go. First question. You've spent 2 hours in a team retro, but the only input you've heard is Dave's. Boardroom or Miro Board?
Boardroom. In Miro, Dave can't hog the space because everyone can add thoughts anonymously, online at the same time.
Correct. Next, you need the team to act on feedback fast. So you turn all those retro notes into Jira tasks.
Miro all the way. And I can assign those tasks to teammates.
You're nailing this. Now, you see hundreds of sticky notes from the Retro. A real mess. But you organize them into 5 themes in just seconds.
Miro, I basically get back an entire hour when I use its AI tools for clustering.
And she's done it.
For a limited time, visit Miro.com/retro now for a free business plan trial to unlock advanced retro tools like private mode, voting, and two-way Jira syncing. That's Miro.com/retro now.
We also talked with Indiana defense attorney Mark Inman, who we've also had on the show before. Mark took some issue with what he felt was the weaponization of the speedy trial motion. Namely, the fact that Allen's defense team has had a signed carte blanche copy of the motion for months, and have been seemingly just been hanging on to it.
Mark also expressed more skepticism that a speedy trial can even happen in a case like this, with so many unresolved issues, and a jury that would need to be brought in and housed from out of Carroll County. He indicated that the rules around speedy trials can be more complicated than they initially appear.
Because if you want a speedy trial, the point is to have a speedy trial, right?
Right.
It's not to pick a time where all of a sudden you think you're going to get an advantage. I don't think. And knowing that you can get congested for continued in a heartbeat. If I'm the judge, I just say, look, we're not moving the trial date, and I'll tell you why. Because I can't get jurors, I can't get hotel rooms, I can't get buses. We can't do this thing that way. And you're the one that requested out of state or out of county juries. But don't just keep throwing darts. How many of them are going to? And like I said, they admitted that was their strategy through their appellate lawyers in the Supreme Court. That there's a moment in time that they feel is appropriate that they're going to, I don't know, keep the states from learning who the 8 odios are that they've got stashed in a witness room somewhere. I don't know.
Is there ever a strategy to doing speedy trial, and what would that be?
Yeah, I suppose there is. If the case is simple and you think one of their witnesses has disappeared, and they won't find him in 70 days. But you always have to keep in mind that, and maybe it's a strategy towards maybe working out a little better deal that, I'm going to put your feet to the fire, and if you can't find this witness, you don't want this guy released. Let's work out a better deal. But once again, as we talked about before, there's no deal to be had in this case, the Delphi case.
No.
So, but I think, in order to do the research on any major case, you need more than 70 days. And people aren't locked up on cases that aren't major unless they've got other holds on them. I mean, keep in mind, let's say, for instance, this was a felony drunk driving case, right?
Oh.
And Allen had cases pending in 2 other counties. Well, the court can release him on this case, but he's just going to go, he's in warrant status in Marion County, and he just goes sits in the jail down there. That happens all the time. That's the balancing act you have to do. Does that make sense?
That does make sense. And could this be like any sort of feint or strategic move on their part that, would make sense or be good for their case?
Not that I can picture. I think they just think that they can keep making a record on the speedy trial thing, but the Supreme Court already told them no. And they're going to get into an argument as to who's responsible for all the delays. And I don't think they can get it. I mean, they've done actions that can still be held contemptible. That means the delay is on the time of that delay is going to be, they're going to be accountable for that. So it doesn't count on the 70 days. But read the Rule 4, and it looks very straightforward. But then you start looking at the case law and all that, which is what I was looking at after you had called the first time. And I mean, there's case after case which denies an appeal based on Criminal Rule 4 for all kinds of different reasons, because it's impractical.
So it's much less cut and dry than it might appear at first.
Absolutely. And keep in mind that the remedy is not dismissal necessarily. I mean, and that's right in the statute. So, I don't.
Thank you so much to Tim and Mark for their time and their great insights.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
Welcome to another round of Drawing Board or Miro Board. Today we discuss technical diagramming with systems architect Maya. Let's go. First question. You've spent 10 hours slogging over a sequence diagram that should have taken 5. Drawing board or Miro board?
Drawing board. And if I'm being honest, Miro would probably cut that time down by half. You know, with its AI tools and ready-to-go templates.
Next, your diagrams become so bulky, it's more complex than the solar system. But all it takes is a few clicks and...
It's Miro. I've used those technical shape packs way too many times.
Now, the final question. Everyone's brought in, but you have to make all these tasks all the way over in Jira. But wait, it's done. Is it...
Miro, easy with its two-way Jira sync. Easy to plot dependencies. Everyone always knows what's up.
And she's done it.
For a limited time, visit Miro.com/diagram now and get a free business plan trial to unlock even more features like advanced shapes, dependency mapping, and two-way Jira syncing. Get started today at Miro.com/diagram now.